Welcome to FCPA Flash, the official podcast of FCPA Professor, moderated by Professor Mike Kaler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by Kroll. Kroll is trusted by companies and compliance officers worldwide to help prevent, detect, and remediate FCPA challenges with scalable end-to-end compliance solutions. From high-volume third-party screening and automated monitoring, to risk-based due diligence, to complex investigations and monitorships. With leading experts, global resources, and advanced technology, Kroll is uniquely positioned to meet all your FCPA needs.
Thank you for listening to the FCPA Flash podcast. This is Professor Mike Kaler, and I invite you to my next FCPA Institute in Indianapolis on September 28th through the 29th. To learn more about the two-day FCPA Institute and how it has elevated the FCPA knowledge and practical skills of a diverse group of professionals, please visit fcpaprofessor.com and click on the FCPA Institute page. Welcome to FCPA Flash. This is Professor Mike Kaler, and in this episode I'm pleased to be joined by Neil Smith. Neil recently joined K&L Gates as a partner in the firm's Boston office, where he's a member of the Investigations, Enforcement, and White-Collar Practice Group. Prior to this, Neil served as senior counsel in the enforcement division of the U.S. SEC for more than 6 years, where he was a member of the SEC's FCPA specialized unit and was the lead SEC attorney on the recent OCZIF and JP Morgan investigations. Thanks for joining FCPA Flash, Neil.
Thanks, Mike. Thanks for asking.
A number of questions today, not surprisingly, concerning the SEC's enforcement of the Foreign Corrupt Practices Act. For listeners' benefit, the SEC claims a piece of the enforcement pie along with the Department of Justice. Specifically, the SEC has a jurisdiction, generally speaking, over issuers, publicly traded companies. My first question is, why do certain SEC FCPA enforcement actions only include a disgorgement amount, whereas others include a disgorgement amount plus a civil penalty, whereas yet other FCPA enforcement actions only include a civil penalty amount? It sort of seems like a buffet, if you will, of remedies. Can you help listeners better understand how the SEC chooses which remedy to use in an FCPA enforcement action?
Yes, absolutely. And I think that the main takeaway for your listeners, Mike, should be that each settlement here and each resolution is fact specific. If you are litigating against, if the SEC chooses to bring charges or is unable to reach a settlement with an individual or an entity, you're going to seek the full gamut of available remedies. In a settled context, there's an ability to negotiate and a desire both on the government side and on an entity side to negotiate. And so there isn't a one-size-fits-all way to resolve one of these investigations. Each one, frankly, is fact-dependent and stands alone. So each time the SEC staff is looking at a company, they're looking at the specific wrongdoing in question, the specific controls in place, the profits earned by that company, the company's cooperation, the company's remediation efforts, and other factors. And again, these are usually heavily negotiated. So the government isn't able, and the SEC isn't able to go to a company and say, we're gonna pick a number out of the hat and we're gonna demand that you pay it, and that's gonna be our settlement number. That's not the way it works. That would not, number one, I don't think the experienced defense counsel would agree to that, or any company. And number two, that wouldn't pass internal muster within the SEC. And so, these settlements within the government have to be fully supported. The DOJ has its sentencing guidelines, and the SEC has its own methods for calculating disgorgement and penalties and other remedies that have to be supported by policies and facts and things like that. So that's a long way of saying, that each of these things has to stand alone and it has to be fully supported internally as well as acceptable in a resolution setting to a company. I think in general, what you see, and maybe what you're, alluding to in your question, is that when DOJ is present as part of a parallel investigation or parallel resolution, as it often is, then their remedy is a criminal fine or criminal penalty, which they will calculate based on the sentencing guidelines and other things, and they factor in a number of things, including, in some cases, profit, but also cooperation and other methods. The SEC, its primary enforcement mechanism on the monetary side here is disgorgement of ill-gotten gains by the entity or any individuals. In that situation, where you have a parallel DOJ criminal penalty, the general practice, I think, for the SEC has been that it's not going to seek a double penalty against the company, and therefore would just seek disgorgement. So, the SEC has the ability, in an FCPA context and other contexts, to seek disgorgement of ill-gotten gains plus a penalty based on the conduct, and there's a calculation that goes into figuring out what that penalty would be. In these cases where you have such a high correlation between SEC and DOJ parallel actions, that's what the SEC does. The reasoning, I think, is one, in particular, of harmless shareholders and investors. You don't need to double penalize a company. If the company's already being penalized by DOJ, the SEC doesn't need to pile on with that and get its own penalty. The ill-gotten gains, frankly, the disgorgement, I think, is the most equitable means of resolving these matters, where you're putting the company back in the place it would have been had they not paid the bribe. So they're not getting any benefit from the bribe. This may change based on the recent Supreme Court decision in Kokesh, in which the SEC's disgorgement remedies were limited. I know, maybe we'll talk about that later, but that may impact how these resolutions happen in the future. I also think there are situations where other federal agencies are involved, or even foreign criminal and regulatory bodies, which can impose their own penalties and fines. And in that case, I think the SEC, takes a holistic view of the overall settlement landscape to determine what penalty and disgorgement is recommended, and what is presented to the Commission, as do other agencies. And I think this, frankly, is an area that practitioners should really watch as we see increased participation from other U.S. agencies like the Fed, as we saw in the J.P. Morgan case, and potentially other U.S. entities getting involved in some of these cases, enforcing their own particular aspect of the securities laws or the banking laws, or other laws, where the government has to be careful that they're not piling on here. That although every investigating agency may want a part of the resolution, and that I can understand that, for the company and frankly for the shareholders, the government has to be very careful that they're not penalizing the company excessively or putting them out of business for that. I think your question also asked, how come sometimes the SEC would impose a civil penalty, but there's no disgorgement, and that, I think, again, would be fact-specific. If it happens to be that there was no ill-gotten gain, for example, there's nothing to disgorge because either there were no revenues for the project, for a variety of reasons it was a loss, or the company stopped the project when it uncovered the bribes and self-reported and things like that, you're going to have a situation where there's nothing to disgorge. And in that case, depending on the conduct and all the other factors I already talked about, there may still need to be, or the SEC may still want some form of civil penalty. And so you'd see that, but perhaps with no disgorgement. For individuals, I think that is also the case. I think when you were resolving with individuals, it's difficult sometimes to prove disgorgement, right? If a person is involved in some aspect of a bribery scheme, but that's 5% of their job or some percent of their job, and they get an overall salary, and there's no way to specifically link profits earned by that individual to the misconduct done in the course of their employment, it's difficult to seek disgorgement there, and a penalty may be the best remedy against such individuals. In other cases, I think there is a calculation. There is a way to do it. This person's income was X, and 50%, 20%, what have you, of their job was working on the corrupt scheme, and therefore we're going to, the SEC is going to seek to disgorge 20% of that person's, gains during the period in question. And again, as I said, for the SEC, I think the seaboard factors will come into play here, as they always do, frankly. And this is where a company's cooperation and remediation could impact the final resolution. The seaboard factors, I'm sure you know, Mike, but for some of your listeners, are a series of factors that the SEC considers when entering into a settlement with a company, including how their cooperation, their remediation efforts, tone at the top, whether they're a repeat offender, et cetera. And so, a company that has been cooperative during the investigation and has sent the right message, has shown the right tone at the top, has shown the right remediation steps, has a better argument that disgorgement should be reasonable and the penalty should be reasonable or non-existent, than a company that has refused to acknowledge wrongdoing, refused to cooperate, has been a pain every step of the way. There's a lot less, in any context, there's a lot less leeway that company's going to have in a settlement than the cooperative one.
Let's stick with disgorgement, and you mentioned the Kokesh decision. This was a development from earlier this summer in which the Supreme Court unanimously held. This wasn't an FCPA action per se, but nevertheless FCPA relevant. That disgorgement is a penalty, and thus disgorgement actions must be commenced within 5 years of the date the claim accrues. How do you think Kokesh will impact future SEC FCPA enforcement actions, both from the enforcement perspective and also from the defense side?
I think it's going to have a significant impact. I think that your question phrases it exactly correctly. That the SEC has long viewed and argued that disgorgement is an equitable remedy. That you are essentially putting a bad actor back in the place that they were in. They would have been in, but for the improper conduct in FCPA cases, the paying the bribe or something like that. The Supreme Court disagreed with that, and so now disgorgement is limited to the 5-year statute of limitations for the SEC. And so, how is that going to impact investigations, and how is that going to impact how companies deal with these issues? I think every company has to factor that in. I think for one thing, there's going to be increased pressure on the government side for companies to enter into tolling agreements, and for individuals as well. Frankly, I think that there will be an increased effort by the government to seek tolling agreements from individuals and companies in all these investigations, including investigations that are just getting started, or maybe where the tires are being kicked, and not sort of a full-blown inquiry. I think the government will want to preserve what it can through an agreed-upon tolling agreement. There's going to be an increased pressure on the government side, I think, to speed up these investigations, and that works for enforcers, the SEC and DOJ, but also for company, which will have different motivations. But how to do that is really the trick. And then for companies, I think the cloud hanging over their head may not be quite as big in some cases with old conduct as you had prior to Kokesh. I think that there's going to be a rush from whistleblowers and other insiders and others that with information to report that quickly, so that the government can start an investigation within the statute and seek that tolling agreement if the company agrees to it and things like that. And I think it really ramps up pressure on the folks at the SEC. And in parallel, the folks at the DOJ that work these investigations in parallel to sort of move these things as quickly as possible and to dedicate resources to the investigation so that they can move quickly.
Of course, the law, including unanimous Supreme Court decisions, really, as a practical matter, only matter to the extent companies don't roll over and play dead, as I've said, when faced with government scrutiny. You mentioned tolling agreements, cooperation agreements, as you well know, and as has been made clear in recent years. The name of the game is often cooperation, which means tolling statute of limitations or waiving statute of limitation defenses altogether. Since the Kokesh decision, there's been 3 FCPA enforcement actions. Granted, 2 were DOJ, so-called declinations with disgorgement. But the one SEC enforcement action since Kokesh was one obviously long in the pipeline before the Supreme Court decision in June. But that was the Halliburton action, where that included a $14 million disgorgement amount, even though the conduct at issue took place well beyond a 5-year statute of limitations. So obviously time will tell what impact Kokesh is going to have. Perhaps it will have some impacts in negotiations and along the margins, but so long as business organizations are willing to toll statute of limitations or waive statute of limitation defenses altogether, I just don't see it having much of a practical impact. Any thoughts on that?
I think that's really going to be the question for companies and their counsel now in the post-Kokesh era is, what do we do with conduct that is either on the bubble of the 5 years or beyond the 5 years? Is it still in our best interest to self-report that to the government? In the past, there was no limitation on disgorgement because it was equitable the way the SEC enforced it. So that has changed. And now companies have to really consider what to do in response to that if they uncover, bribery or other misconduct that's a little bit older. On the one hand, if you don't self-report and the statute of limitations passes and, the SEC hasn't started an investigation, then, perhaps the company is out of the woods regarding SEC disgorgement. However, nothing says that the SEC can't bring a case and seek injunctive relief or other, penalties or equitable remedies that remain in play. Injunctive relief is and remains an equitable remedy. And so for egregious conduct or conduct where the evidence is ironclad, even though old, you could still see the SEC bringing that and just getting the injunction and the equitable remedies that are still available. And so then you've got the company that maybe they're not disgorging their ill-gotten gains, but they're still taking that hit, that negative press hit, for having to either have a resolved or a litigated SEC action. And I think, frankly, a company needs to understand, and I think that over the next couple of years we're going to see how the SEC plays this, what conduct constitutes the violation, right? I mean, is it the first bribe? Is it the contract? Is it a later payment? Are you making annual payments to an agent or an intermediary that constitute bribes? The first one's out, but maybe the more recent ones are in. Are there acts by co-conspirators that remain within the statutory period? Are certain books and records violations ongoing? Are there controls violations that are ongoing still within the period? Does the company's receipt of the benefit from the bribe extend the date of the violation? Is there ongoing activity here? I think these are all factors that a company has to consider when it learns of this conduct, both either because the SEC comes calling or because they learn of it internally through their own audit or other procedures. That's a real. Those are serious considerations that a company really has to weigh how they play that. For individuals, if a person is outside the U.S. during the tolling period, the statute doesn't run, and so they could still be, on the hook if they haven't been inside the U.S. And so counsel representing individuals in these investigations that are either asked to sign a tolling agreement or are wondering about the extent of their liability, that takes further consideration. What have we done? Have we traveled to the U.S.? Have we been in the U.S. as part of these meetings? Because the SEC can still go after them, if there's the appropriate nexus and personal jurisdiction and things like that. And then, as I said earlier in response to this question, I think on the DOJ side, it's a completely different calculus. The DOJ has ways to toll the statute, other than a tolling agreement with the entity or the individual. If, for example, they're seeking records overseas and foreign bank records, and they've made those requests, there's a way for them to toll the statute. So, for a company, you may not know if that's happened in the background. And so you may not know if DOJ is going to still toll the statute. So you might not have to deal with SEC disgorgement outside of that 5-year window, but you may still have to deal with DOJ's criminal final penalty. All that has to be considered when you're presented with these issues and decide whether, do I want to self-report this or not, and how do I play these issues now that are 6 years old, 7 years old. But on the defense side, I think one thing is clear, and that is the incentive to avoid paying these huge disgorgement figures needs to be balanced against whatever cooperation credit the government is going to give you for entering into a voluntary tolling agreement under the Kokesh era. I think when I was in the government, and I think folks in the government believe the benefits from cooperation in these investigations are clear. You've got a smoother relationship, quicker investigation, a targeted scope of the investigation, the ability to present your findings to the government, things like that sort of lessen the ramifications on the back end, monitorships, etc., that you face. But what I heard when I was in the government, and I'm sure what I will hear now, is that from the defense bar, is that the benefits from cooperation are not always clear to clients, at least not in a way that can be easily explained to boards and shareholders. And so the SEC in particular here faces a real challenge communicating the benefits from entering into a tolling agreement for conduct that may hit the 5-year limit or is about to hit the 5-year limit. Companies and individuals are going to need to think long and hard about whether they enter into those agreements and what benefit do they get. It'll be interesting to see how the government reacts if companies start refusing to enter tolling agreements in certain situations. It'll be interesting to see if the government is able to speed up investigations so that this becomes less of an issue. And so I think it's a fascinating time in the next year or so. Just going to really see how SEC responds and how the bar responds to this.
Yeah, time will certainly tell, and you can be sure my website, FCPA Professor, will be tracking this issue closely. Let's switch gears to internal controls. SEC FCPA enforcement actions against issuers, often contain a long laundry list of internal control findings or violations. And the question I have is, on what authority does the SEC base its decision that X, Y, or Z is an internal controls violation, given the fact that the statutory standard is merely that issuers shall, quote, devise and maintain a system of internal accounting controls, and here's the key language, sufficient to provide reasonable assurances that the 4 financial objectives set forth in the statute are met. And furthermore, there's really no rule or regulation which speaks to what is an effective, a reasonable internal control. So when the SEC says X, Y, and Z is an internal controls violation, on what authority are they basing that finding on?
Well, I think that the statute is pretty broad and is actually a powerful tool for the government. I think that Exchange Act 13B2A and B2B really lay out broad authority to regulate in this area. And it's I think that you mentioned devise and maintain the internal accounting controls sufficient to provide. I mean, I think what those controls need to provide is really the key here. Number one, transactions that are executed in accordance with management's authorization, general and specific. Number two, that they're recorded as necessary to permit the preparation of accurate financial statements, comply with GAAP, things like that. The soundness and the reliability of public companies' books and records is one of the hallmarks of our financial system, and certainly one of the things that the SEC cares the most about maintaining. But also that that these transactions are recorded to maintain accountability for assets, and that's a big one in this space as well. And that access to companies' assets is permitted only in accordance with management's general or specific authorization. And so, again, this is broad authority for the government to enforce this. If a company doesn't know where its money is going, or it's falsely recording where that money is going, then that can violate the statute. And all public companies have management directives in place, I expect, forbidding the use of company assets in illegal transactions. So right there, if if you're paying bribes to foreign officials, that's an illegal transaction under U.S. law, and likely an illegal transaction in whatever foreign country that you're operating in.
Now, those are sort of the easy ones, and I think all reasonable minds would agree that that is an internal control violation. But, when the SEC finds that the company's code of conduct was vague, therefore an internal control violation. The company failed to follow up on third-party agent references, therefore that's an internal control violation. What authority, what rule, what regulation, what statutory authority is the SEC relying upon, given that the internal controls provisions speak to financial objectives?
Right, and so I think that is, you're right. It is internal financial controls that are or internal accounting controls that are being enforced here. But company compliance is part of that, and certainly is seen as part of that. By the SEC. I think that if you're in a situation where a company has financial controls in place for a number of things, entertainment of clients, entertainment of foreign government officials, payments to agents, things like that. Those controls are in place to make sure that all the other enumerated things happen, that assets are being used in accordance with management directive, etc., that you're not using your funds, company funds, to break the law or do something that's improper, unduly influence, a client, or unduly influence a government official. And so, how does the statute, frankly, doesn't need to and shouldn't articulate exactly what the right financial controls are, because there's not a one-size-fits-all model for internal controls. That's going to really depend on what the company does. Is the company, operating in a low-risk country, and they're not selling to public entities, and they're, there's a lower risk that they're going to be approached for or feel the need to pay a bribe? Okay, you've got certain controls in place. If you're in an extractive industry and you're operating in high-risk countries that score high on the trace and other rankings for corrupt countries, and you're dealing in an industry known for corruption, and you're dealing directly with government entities that can, or government officials that can frankly often operate with impunity, then you're expected to have a higher degree of controls in place, and a lot of that can be due diligence. And so I think from the SEC's perspective, I think what you look at is, you don't come in and say, this is what you should have done, right, every time, and say, these are the rules that we think every company needs to follow. You look at what the company had in place. Number one, did they have these controls in place? Okay, what were they? Were they sufficient, or were they completely weak? Was the company paying attention to this? Were compliance folks involved in these decisions, etc.? And the real issue that you can't say this in a settled action, I think, but the real issue that I certainly wanted to look at in an investigation when I was looking at a company's controls, and you always do, is this did this company have real controls in place, or is this a paper policy? Did they, hire a law firm to put some controls on a piece of paper and have everybody sign it every year? But there was no teeth to it. Nobody followed up on it. Nobody was watching the folks that were doing it. They were checking the box, and that was it. Was it a paper policy, or was it something where the company honestly cared about this? They were checking up on it. They were doing their best to stop this. And oftentimes it's the individuals that are responsible for this, and the company's on the hook for the actions by the individuals, either circumventing the controls by, I know I can't do this, but I'm going to do it anyway. I know I have to be truthful in reporting why I'm paying to this vendor or agent, but I'm not going to do that, because if I do that, the company's not going to pay it because they know it's either a bribe or it's too risky, etc. And then, are the compliance folks doing their job? Are they checking on these vendors? Are they appropriately measuring the risk in certain transactions in certain countries and certain industries, so that they are, undertaking this due diligence and things like that when it's appropriate? I think that's the critical issue for us, or was, I say us, but that was the critical issue, when I was looking at these things at the SEC, and there's a lot of in-house knowledge at the SEC, and I think DOJ is trying to increase their own in-house knowledge as to what's reasonable here. What do accountants think?
And of course, It's always easier, and the SEC and the DOJ, for that matter, at least from my perspective, have the perfect benefit of hindsight. They know of those 10,000 third-party agents that it was Agent X. And now that we know it's Agent X, of course there's always going to be things the company could have or should have or would have done better. But from my perspective, at least, that's like, let's use a sports analogy here. That's like saying the Golden State Warriors, notwithstanding being NBA champions this year, had a terrible season by focusing just on one game or by focusing perhaps just on one possession. Does the SEC, from your perspective, when you were at the agency, take a more holistic view of saying, okay, this one agent was problematic, but the fact of the matter is this company had 9,000 other agents and none of them were problematic?
That certainly becomes part of it. I think that, and that sort of plays into how it gets, and how it gets described, frankly, sometimes in the settlement document. I think you want to, as I said, you want to make clear to readers, right? The company knows, and you've made clear to the company what you think they did, and you've laid out for them what you think is happening. But you want other companies, other lawyers to look at this and think, how can I avoid this myself? And so you want to give as much specificity as you can. You're not unlimited in that because it's a settled document usually, but you certainly want to point out, hey, these are the real issues here, and it's not because, the company did everything it could and this still happened. The Morgan Stanley case from Hong Kong from several years ago where the company was not, hit, but the individual was. That was a company, if you look at those documents, the company had all the right controls in place and they were enforcing them. This guy nonetheless was able to go around them, but the company didn't take the hit for that. So I think, on a controls violation, you really want, the goal, I think, for the SEC is you want companies to know what they should be doing and how they should be enforcing this, and you want their compliance people to be empowered internally, and their legal folks to be empowered internally to say, hey guys, we need to have a policy that does the following, and if we don't, this is what's going to happen. I also think that it may look like sometimes these are add-ons in settlements. I don't think that they are. Now there's no additional, usually if you're in a parallel action, again, as I said before, there's no additional penalty for a controls violation, and there's no additional disgorgement for a controls violation. So the money the company is paying is the same, but you really want to delineate. The SEC really wants to delineate what the conduct was and what the violations were, and that's why it's included. There are cases where, but as I said previously, you really have to make your case internally if you're the SEC before it can go into a settlement document. The folks at the SEC are not going to say, oh, this is a bribe case, I'm going to check the box on internal controls. That's not acceptable to other divisions. That's not acceptable to the commission. You have to articulate what financial controls were violated here, what books and records, because they can go hand in hand, but not always. What books and records, were violated here. And I think if it was just a check the box, every 30A from the SEC also gets books and records and financial controls, you wouldn't see that. You wouldn't see cases where you don't have both of those, where you don't have books and records like you've seen in some of the hiring cases, because there were no books and records that were impacted by the conduct. I think that's the overall takeaway I would want to have if I was a company is, how can I use what's been laid out in this settlement document to, if I'm a compliance person, to empower myself internally to make sure that we don't have a paper policy.
Final question. The FCPA turns 40 in a couple of months, perhaps a reflective point for all of us involved in this space. If you were FCPA king for a day, which I guess I just made you, what about the FCPA, either the statute itself or its enforcement, would you change and why?
So, I don't think that I would change the statute. I think that it is appropriately broad for enforcement purposes, and it encompasses conduct that is appropriately either criminalized or made a violation on the civil side, and it gives the government folks the power to investigate these things, from a variety of aspects. I think that, if there was one thing about this practice that I would change, it would be speed. I think that these investigations take a long time, and that is something that I think weighs on companies and defense counsel, but also weighs on government investigators and DOJ prosecutors. I think that there are certain aspects, certain parts of the nature of the beast that you can't avoid if you're dealing with witnesses overseas and you're dealing with bank records and other documents overseas. It takes time to get those, and so how could you speed that up? If you're FCPA king, you could put the timing for getting records from a foreign jurisdiction in line with the domestic response to a domestic subpoena. So you're talking about weeks and months and not years, as you are in some investigations. I think that would really go a long way to making the process better understood on the defense side, making it seem less daunting on the defense side, so your self-report isn't such a risk, and certainly would help on the government side, so that staff and at the SEC and prosecutors and folks at the FBI and the IRS and all the other different entities and agencies that are investigating this stuff are able to do that in a manner that they're not staring at the barrel of a 5-year plus investigation. Increased resources at DOJ and SEC. I think that is helpful. As always, I think forensic accountants, the use of experts, which I think we've seen on the government side increasing in recent years, where you're having folks analyze these complicated, sophisticated money trails, and tracking it down would also be helpful. I think that the folks at the DOJ and the SEC that investigate this are very good. I think the creation of these specialized units has helped, because you really want folks that understand how these things work and understand how bribery works, both in general and then in specific cases, and giving those folks the ability to focus on FCPA and take the time to investigate is really helpful. But it's also tough because as I said, you're staring at these long investigations that take a long time. And then I think the final thing I would say is something I said earlier. Well, two things I would say. Number one, I think it's better to empower compliance and legal folks to stop transactions that are too risky. Oftentimes that gets overruled by the business folks. It's a business decision, and we're willing to take the risk. If compliance and legal folks had more authority to overrule that in these high risk red flag transactions, maybe you don't have 100% certainty that a bribe is being paid, but it certainly looks fishy. If you internally at a company have the ability to stop that transaction, I think that would go a long way to cutting down on bribery. And then, as I said before, I think that the government needs to do a better job making clear the benefits from self-reporting and cooperating, making those benefits tangible to companies and individuals, to sort of speed these things along and to make it a less difficult decision for companies to come forward and self-report. I think, as many people have said, you're more likely to get caught today than you were in any time in the past if you pay a bribe. And so, that if you understand what the benefits are a little bit better and how it's going to help you in the long run, I think then your incentives to self-report go up.
Well, thanks for sharing those insights. Today's guest has been Neil Smith. Neil recently joined K&L Gates as a partner in the Boston office, fresh off of his stint at the SEC's FCPA unit. And thank you for taking your time today and sharing your insights with FCPA Flash listeners.
Thanks, Mike. I appreciate it.